Hey, what's up, guys? Travis Britt here with SOCEprep.com, where we get you ready for the statewide officer certification exam, whether you're in a basic recruit training program or you want to transfer your certification from out of state into the beautiful state of Florida. So let's knock this question out, guys. It's question 22 of 200. It's on my website, SOCEprep.com. I've got a comprehensive practice test at the end of 20 hours of direct instruction. With guided notes, which are free, by the way. If you want to go get them, head over to my website, soceprep.com, check them out. But let's get to this question. Enough with the plugs, right? So this question says, in the case of Graham v. Connor, right? So we got a V. What does the V mean? It's a versus, all right? So it is a lawsuit. And a lot of these questions that you're getting on the statewide officer certification exam are going to be United States Supreme Court cases, this one included, right? So they're landmark United States Supreme Court cases, right? So that's a mouthful, but they're very important, right? Because they're going to tell you in the lower courts how to do their job. So history doesn't always repeat itself, but it rhymes, right? So with that being said, we are going to use our case law to keep ourselves out of trouble and to remain constitutional. So in the case of Graham versus Connor, the United States Supreme Court established which important principle regarding the use of force by law enforcement officers. So we got a couple things going on here. Graham versus Connor, United States Supreme Court. What is the principle regarding the use of force by law enforcement officers? Let's start working through these and keep or scratch. So A says a requirement for law enforcement to use the least intrusive means when making an arrest, right? The least intrusive means while making an arrest. The requirement to use the least intrusive means while making an arrest. That sounds hunky-dory, right? But that's not true, all right? Police officers are not required to use the least intrusive, right? You want to use the least intrusive. We're not out there to bully the public or to coerce them into fear. But there are times where intrusion is appropriate and reasonable, right? If I got a child molester who has kidnapped a child, a judge has signed off on a warrant, we're trying to find a child, and it's supposedly in this clown's house. I'm not worried about least intrusive at that point. I got probable cause to turn his life upside down, and that's what I'm going to do until I find that child, right? And it's nothing personal, it's business at that point. So I don't really love this one, but we're going to scratch that one off the board. B says the standard for determining when a suspect is in custody and entitled to be informed of their rights. So the standard for determining when a suspect's in custody, so we got custody, right? So they're not free to go. And it looks like they could possibly be interrogated, right? Could self-incriminate. So they need to be informed of their due process rights. So this is a play on what case, guys? It's another United States Supreme Court case. It is Ernesto Miranda versus Arizona, right? So that's not a great answer choice. We're going to scratch that one as well, which states that if you have an individual in a custodial setting, meaning they're not free to go, and you're asking them or interrogating them, asking them questions that could self-incriminate, you better stop. Better make sure they understand their right, their Fifth Amendment right to not self-incriminate, and have them waive those rights before they talk to you, because in a suppression hearing, you get everything after the fact thrown out if you're not following due process, right? We talked about the fruits of the poisonous tree. That would be the fruits of the poisonous tree if you didn't follow due process. So we're going to scratch that as well. C says the standard for assessing whether the use of force by a law enforcement officer is reasonable under the Fourth Amendment. We'll hold on to it. And then D says the prohibition against the use of race as the sole factor in making traffic stops. Thank God there is no case law where we have to say, hey, we're no longer going to pull people over by the color of their skin. Does it happen? Absolutely. Should not be happening, right? And if you're doing that, your acronyms are going to change really quickly from PC, meaning probable cause, to PC, meaning protective custody, because you're going to get your ass locked up, right? As you should, right? So D, we're going to scratch that off the board. The 14th Amendment is what protects people, equal protection under the law. It defines citizenship, and it provides equal protection under the law. So we don't have a case law. And Graham versus Connor is absolutely not about race. It was a case about use of force with an individual that had diabetes and needed orange juice, and the police officers thought that he was a suspect in a armed robbery. So the correct answer, guys, is C. The standard for assessing whether use of force by law enforcement officers is reasonable under the Fourth Amendment. Fourth Amendment is what? No unreasonable search and seizure, right? So if we are seizing bodies, right, we are searching bodies, right, we are or stopping people and intruding, right, on their freedom to move about, then it's a Fourth Amendment issue. Is it reasonable? I don't know. Would 10 other officers do it? That's what the objective reasonable clause is. A reasonable prudent person would do it over and over and over again in the same situation, and it's likely objectively reasonable. So C is your correct answer. I'm going to pick it. I'm going to stick it. I'm going to move on, guys. If you like this content, check me out at soceprep.com. I've got a free study guide over there with 17 pages of free resources that can help you if you want to go old school. If you want to buy one of my study plans, I can save you a lot of time. My time is valuable, so I like to take shortcuts. I can offer you one, right, where you don't have to spend thousands of hours reading those books that are boring. Or, you can do whatever you want. Continue to use the videos as you do. Give me some feedback, guys. If you like these videos, like, comment, subscribe, share them with your friends in your basic recruit training programs or your academies. And show me some love, right? Hit the like button, comment, this, that, and the other, guys. Let me know if I can help you out. Info@copprep.com, soceprep.com, Travis Britt, and we're out. Thank you.